I thank Bar Council of Maharashtra and Goa for giving me this opportunity to address all of you on the topic of consumer protection and arbitration, and to share my experience on these two topics. Good evening, the members of Bar Council of Goa and Maharashtra, and advocates and applicants who have applied for the post of members of District Consumer Dispute Redressal Commission. I am told that large number of applicants are likely to apply in response to the advertisement issued by the Bar Council of Maharashtra and Goa for the post of member of State Consumer Disputes Redressal Commission, as well as President and members of District Consumer Disputes Redressal Commission in the state of Maharashtra, established under the provisions of Consumer Protect Act 2019. I am very happy to say that Bar Council has taken such steps to invite the applications for the post of member of State Consumer Dispute Redressal Commission, as well as President and members of District Consumer Redressal Commission in the state of Maharashtra. Basically, I would like to share my experience on the merits, demerits of the proceedings under the provisions of Consumer Protection Act, as well as arbitration, as also the pitfalls in respect of the proceedings permissible under both the acts. The Consumer Protection Act seeks to provide for better protection of the interest of consumers and for the purpose to make provision for establishment of authorities for resolution and settlement of consumer disputes. On the other hand, Arbitration Act is a legislative framework that governs process of arbitration. Arbitration is an alternate dispute resolution mechanism where parties involved in a legal dispute agree to submit their case to an arbitrator rather than going to the court. As you all are aware that under section 89 of the Code of Civil Procedure, arbitration is one of the alternative dispute resolution mechanism in addition to conciliation and mediation. Lok Adalat is also one of the alternative dispute resolution. I will basically tell you what is the difference between the remedies available under the provisions of Consumer Protection Act as well as arbitration. The definition of complainant is provided under section 2(5) of the Consumer Protection Act 2019, which includes a consumer or any voluntary consumer association registered under any law of the time in force. The central government or any state government or central authority, one or more consumers where there are numerous consumers having the same interest. In case of death of a consumer, he is legal heir or legal representative, or in case of a consumer being a minor, he is parent or legal guardian. Consumer is separately defined under section 2(7) of the said Act, which says that a person who buys any goods for a consideration which has been paid or promised or partly paid and partly promised, or under any system of deferred payment, and includes any user of such goods other than the person who buys such goods for consideration paid or promised, or partly paid or partly promised, or under any system of deferred payment, when such use is made with the approval of such person, but does not include a person who obtains such goods for resale or for any commercial purpose, or hires or avails of any service for consideration which has been paid or promised or partly paid and partly promised, or under any system of deferred payment, and includes any beneficiary of such service other than the person who hires or avails of the services for consideration, paid or promised, or partly paid and partly promised, or under any system of deferred payment, where such services are availed of with the approval of the first mentioned person, but does not include a person who avails of such service for any commercial purpose. Commercial purpose is further clarified under the same provision. It says that the expression commercial purpose does not include use by a person of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. The expression buys and goods and hires or avails any services includes offline or online transaction through electronic means or by tele-shopping or direct selling or multi-level marketing. Consumer dispute is again defined under section 2(8), which means a dispute where the person against whom a complaint has been made denies or disputes the allegation contained in the complaint. Deficiency is defined under section 2(11). The Consumer Protection Act establishes the Central Consumer Protection Council, whose primary object will be to promote and protection of the consumer's rights under Consumer Protection Act. It envisages the establishment of District Consumer Dispute Arbitration Commission under section 28 in each district of the state, which shall be known as District Commission. The District Commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration does not exceed 1 crore rupees. Another forum is State Consumer Disputes Resolution Commission in the state, which is also known as State Commission. The State Commission shall have jurisdiction to entertain the complaints where the value of the goods or services paid as consideration exceeds rupees 1 crore but does not exceed rupees 10 crore. The State Commission also entertains appeals against the orders of any District Commission within the state. The State Commission also has a supervisory jurisdiction over the proceedings of the District Commission. State Commission also has the power to transfer the cases pending before a District Commission to another District Commission within the state if the interest of justice so requires. The other authority under the said Act is National Consumer Disputes Redressal Commission, who has jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceeds rupees 10 crores. Any person aggrieved by an order made by the State Commission may prefer an appeal before the National Commission. An appeal shall lie to the National Commission from any order passed in appeal by any State Commission. If the National Commission is satisfied that the case involves a substantial question of law, the National Commission also similarly exercises supervisory jurisdiction over the proceedings of the State Commission. And the last remedy available under the Consumer Protection Act is that any person aggrieved by the order passed by the National Commission may prefer an appeal against such order to the Supreme Court within a period of 30 days from the date of order. As against this, as far as Arbitration Act is concerned, Arbitration Act can be invoked provided there is an arbitration agreement as defined under section 7 of the Arbitration Act. A party must be a party to arbitration agreement, and if dispute arises, such disputes can be referred to arbitration. Arbitration Act does not provide for any such ceiling as is provided under the Consumer Protection Act for the purposes of deciding the pecuniary jurisdiction. There are three authorities under the Consumer Protection Act which are empowered to decide the dispute originally depending upon the pecuniary jurisdiction of the claim. However, under the Arbitration Act, an arbitrator can be appointed to decide the claims irrespective of the amount involved, whether it is a sole arbitrator or there is a panel of 3 arbitrators. Whether it is a sole arbitrator or panel of 3 arbitrators, it depends upon the agreement entered into between the parties. If the agreement is silent about the number of arbitrators, sole arbitrator has to be appointed under Section 10 of the Arbitration and Conciliation Act 1996. The agreement provides for appointment of 3 arbitrators. Parties can appoint 3 arbitrators, but normally the court tries to convince the party to refer their disputes to sole arbitrator instead of 3 arbitrators to avoid cost heavily required to be incurred and also time. Now, what can be referred to arbitration? As we have seen, the provisions of Consumer Protection Act can be invoked only by a particular set of complainants. They may be consumers, they may be other persons falling under the definition of consumer, and only if cause of action arises which falls under the provisions of Consumer Protection Act. There is a limited power and limited set of circumstances of cause of action where disputes can be referred to consumer forum. As against that, as far as Arbitration Act is concerned, any dispute which is a dispute in personam and which is not to be tried by a court having exclusive jurisdiction, all other disputes can be referred to arbitration, provided both the parties are parties to arbitration agreement. Even if there is no agreement in writing, in a particular agreement or in a writing, parties can enter into an arbitration agreement even during the pendency of dispute by filing that agreement in the pending dispute, and court can pass an order referring the parties to arbitration by taking such agreement on record. Now, even if arbitration agreement is there, the question arises whether action in rem, where not only the parties to arbitration agreement but a third party or the world at large may be affected because of the outcome of the arbitration proceedings, whether can be referred to arbitration. Supreme Court in case of Booz Allen's case, a well-known case, I will give you the citation. Booz Allen and Hamilton INC versus SBI Home Finance Limited, 2011, 5 Supreme Court cases 532, has held that the arbitral tribunals are private fora chosen voluntarily by the parties to the dispute to adjudicate their disputes in place of courts and tribunals which are public fora constituted under the laws of country. Every civil or commercial dispute, either contractual or non-contractual, which can be decided by the court, is in principle capable of being adjudicated and resolved by arbitration unless the jurisdiction of the arbitral tribunal is excluded either expressly or by necessary implication. Adjudication of certain categories of proceedings are reserved by the legislature exclusively for public fora, such as matter for public policy. Certain categories of cases, though not expressly reserved for adjudication by public fora, may be necessary implication stand excluded from the purview of private fora. Consequently, where the cause or dispute is inarbitrable, the court where a suit is pending will refuse to refer the parties to arbitration under Section 8 of the Act, even if the parties might have agreed upon arbitration as the forum for settlement of such dispute. Supreme Court has carved out some of the non-arbitrable disputes in the said well-known judgment in case of Booz Allen, such as disputes relating to rights and liabilities which give rise to or arise out of criminal offence, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody, guardianship matters, insolvency and winding up matters, testamentary matters, grant of probate, letters of administration and succession certificate, and eviction or tenancy matters governed by special statutes where the tenant enjoys statutory protection against eviction and only the specified courts are conferred jurisdiction to grant eviction or decide the dispute. Judgment of Booz Allen has been subsequently considered by the Supreme Court in the subsequent judgments and also by Bombay High Court and various other high courts in this country. Therefore, it is clear that the scope of arbitration is larger than the disputes which can be referred to the forum under the provisions of Consumer Protection Act 2019. But it cannot be said that the proceedings available under the provisions of Consumer Protection Act are not to be accepted or invoked by the parties. Certainly, there are various benefits of going to the Consumer Protection Act in certain set of circumstances where the Consumer Protection Act entertains the proceedings for payment of compensation. The provisions of National Justice Act, which are part of Civil Procedure Code or Evidence Act, are attracted to the proceedings under the provisions of Consumer Protection Act. Similarly, provisions of natural justice are also applicable to the arbitral proceedings. However, there is a specific provision under Section 19 of the Arbitration and Conciliation Act which says that the arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Subject to that part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting its proceedings. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this code, conduct the proceedings in the manner it considers appropriate. The power of arbitral tribunal under section 3 includes the power to determine the admissibility, relevance, materiality and weight of any evidence. Now, there are views taken by our court and also by Supreme Court in series of judgments that though arbitral tribunal is not bound to follow the provisions of Code of Civil Procedure or the Indian Evidence Act, but arbitral tribunal is in any event bound to follow the principles of natural justice. The view also taken is that the provisions of CPC as well as Evidence Act also basically complies or requires or has element of principles of natural justice. Therefore, though technically speaking section 19 provides that arbitral tribunal is not bound by the provisions of CPC or Evidence Act, by and large, unfortunately, provisions of CPC and Evidence Act are extended by the arbitral proceedings. Now, limitation prescribed under the Consumer Protection Act, I must invite your kind attention to. It is under section 69 of the Consumer Protection Act 2019, which says that the District Commission, the State Commission or the National Commission shall not admit a complaint unless it is filed within 2 years from the date on which the cause of action is arisen. Notwithstanding anything contained in subsection 1, a complaint may be entertained after the period specified in subsection 1 if the complainant satisfies the District Commission, the State Commission or the National Commission as the case may be, that he had sufficient cause for not filing the complaint within such period. Provided that no such complaint shall be entertained unless the District Commission or the State Commission or the National Commission as the case may be records its reasons for condoning such delay. Now, as far as Arbitration Act is concerned, in view of section 43 of the Arbitration and Conciliation Act, the Limitation Act 1963 shall apply to arbitrations as it applies to proceedings in court. For the purposes of section 43 and Limitation Act 1963, an arbitration shall be deemed to have commenced on the date referred in section 21. So, section 21 says that once a notice for appointment of arbitrator in respect of a particular dispute is served upon the other side, the arbitral proceeding commences and limitation stops. In view of the fact that the Limitation Act applies to the arbitrations as well as proceedings in court. Section 5 of the Limitation Act is not applicable so far as Arbitration Act is and so far as proceedings under Arbitration Act are concerned. Such powers are available, however, to the District Commission, State Commission or the National Commission, provided a sufficient cause is made out and reasons are recorded by such forum while condoning delay. That is one additional plus factor according to me, and provided under the provisions of Consumer Protection Act. However, in case of Arbitration Act, if your claims are time barred, arbitrator has no jurisdiction to condone delay even if sufficient cause is made out, and more particularly in view of the fact that Section 5 is not applicable. Another aspect which I must consider is about the payment of fees. Under the Consumer Protection Act, read with Consumer Disputes Redressal Commission Rules 2020, there is no fee payable in case of the value of goods or service paid as consideration up to rupees 5 lakhs. If it is above 5 lakhs and up to and above rupees 10 crores, the maximum fees payable is rupees 7,500, minimum payable is 200, depends upon the amount of claim between 5 lakhs and 10 crore. In so far as Arbitration Act is concerned, in view of the amendment provided in the year 2015, and more particularly 23rd October 2015, if the matter is referred to arbitration and if arbitrator is appointed under Section 11 by the court under Arbitration and Conciliation Act 1996, in that event the minimum modal fees prescribed under the 4th schedule in respect of a sum in dispute up to rupees 5 lakhs is rupees 45,000, and in case of sum in dispute above rupees 20 crores, it is rupees 19 lakhs 87,500 plus 0.5% of the claim amount over and above rupees 20 crores with the ceiling of rupees 30 lakhs. And if matter is referred to sole arbitrator, he is entitled to 25% more, that is over and above rupees 30 lakhs if the sum in dispute is above rupees 20 crores. Supreme Court has recently construed this provision and has held that a separate amount of fees prescribed under the 4th schedule is required to be paid in case of counterclaim, because counterclaim also is a claim. As far as fees is concerned, if the matter is referred to the arbitrator by appointing an arbitrator by the court in an application under Section 11, then Schedule 4 fees will apply. However, if parties have appointed arbitrator in respect of a dispute outside the court without intervention of court, in that event arbitrators may charge any amount which they feel reasonable, subject to the parties if they agree for a particular amount. So, from fees point of view also, according to me, the remedies available under the provisions of Consumer Protection Act, read with rules, is economical than the proceedings prescribed under the provisions of Arbitration and Conciliation Act. As far as challenge to the orders against the Consumer Forum at the district level, we have seen that an appeal lies to the State Commission, thereafter second appeal to the National Commission, and the third proceedings available under the provisions of Consumer Protection Act is the Supreme Court. However, as far as Arbitration Act is concerned, if an arbitral award is made by the arbitrator, that award can be challenged in the High Court, or in case of a cause of action having arisen outside the Greater Bombay, the before the district court under section 34, followed by an appeal in High Court under section 37. Once an order is passed under section 37 in that appeal, there is no second appeal prescribed to the High Court. Only a special petition under Article 136 can be challenged, can be invoked against the order that will be passed by the appeal court under section 37. As far as grounds of challenge under section 34 are concerned, they are also very limited. You can't challenge the award on any ground you feel comfortable. Specific grounds are there. Findings of fact cannot be challenged. Only very limited grounds, if your case would fall, you can challenge that award, and if you fail in the petition or one of the parties succeeds in getting the award set aside, in that appeal is available under section 37 of the Arbitration Act, either before the district court or before the High Court. So there is limited intervention in view of section 5 of the Arbitration Act if you invoke the provisions of Arbitration Act. Only those proceedings which are permissible under the provisions of Arbitration and Conciliation Act, proceedings can be entertained by the court and not any other proceedings. So scope of challenge to an order is very limited. So far as interim relief is concerned, I must consider this point also, that I don't find any provision under the provisions of Consumer Protection Act for granting any interim relief. Whereas, so far as arbitration proceedings are concerned, there are two provisions applicable for grant of interim measures, or we will call it interim reliefs. One is in case of interim reliefs, the powers are prescribed with the arbitral tribunal under section 70 in certain circumstances, whereas certain powers are also given to the court under section 9 to grant interim measures. It is further provided that if arbitral proceedings have been commenced, then court shall not exercise powers under section 9 of the Arbitration Act unless the interim measures provided under section 17 of the Arbitration Act are not efficacious. Take for example, if a party seeks to apply for appointment of a court receiver, then though arbitrator is appointed, he would like to apply for appointment of court receiver by invoking section 9 of the Arbitration and Conciliation Act. Because arbitral tribunal has no power to appoint a court receiver. Court receiver mechanism or machinery is available to the court proceedings and not to the arbitral proceedings. Arbitral proceedings are private proceedings, private forum for adjudication of dispute. So this is one lacuna in the Consumer Protection Act where there is no provision for grant of interim relief. Another part is about the evidence. No doubt the provisions of Consumer Protection Act clearly provides that provisions of the principles of natural justice applies in the proceedings before the forums prescribed under the provisions of Consumer Protection Act. Now, I have not come across any such order subject to correction where any evidence, oral evidence is laid before the consumer forum. Now, what is the consequence of that? The consumer forum may decide based on the documentary evidence that will be produced by the parties, or if there is no such documentary evidence, then on the basis of pleadings filed by the parties. Whereas in case of arbitration, though arbitral tribunal is not bound by the provisions of Evidence Act or the CPC, principles of natural justice applies there also, and more particularly if there is a case of compensation or damages. In that event, normal course is that some evidence has to be laid by the parties to prove the quantification of claim for damages, which may not be the case in case of proceedings before the consumer forum. In one of the judgment before the Honorable Supreme Court, and more particularly in case of Charan Singh versus Healing Touch Hospital and others 2007 Supreme Court cases 668. The Supreme Court has held that consumer forums are required to make an attempt to serve the ends of justice so that compensation is awarded in an established case which not only serves the purpose of recompensating the individual but which also at the same time aims to bring about a qualitative change in the attitude of the service provider. Indeed, calculation of damages depends on the facts and circumstances of each case. No hard and fast rule can be laid down for universal application. While awarding compensation, a consumer forum has to take into account all relevant factors and assess compensation on the basis of accepted legal principles on moderation. It is for the consumer forum to grant compensation to the extent it finds it reasonable, fair and proper in the facts and circumstances of a given case, according to the established judicial standards where the claimant is able to establish his charge. It is not merely the alleged harm or mental pain, agony or physical discomfort, loss of salary and emoluments, etc., suffered by the appellant which is in the issue before the Supreme Court. It is also the quality of conduct committed by the respondents upon which attention is required to be founded in case of a proven negligence. Though these principles are held, but in practice, what is noticed is that though there is no oral evidence required to be laid before the forum under the provisions of Consumer Protection Act, and Consumer Protection Act, the forum grants some claim for compensation. But again the criteria is that whether it is on the basis of some thumb rule or there must be some material to be placed on record before the consumer forum for granting compensation. What is an adequate compensation without any evidence, that is again a matter of debate. Whereas in case of arbitration, though arbitral tribunal is not bound by the provisions of Evidence Act, but normally in case of compensation or damages or where there are allegations of breach of contract which results in claim for compensation, parties need oral evidence. And taking into consideration such oral evidence as well as documentary evidence, arbitral tribunal grants some claim for compensation. In one of the judgment, in case of Asma Roy versus Yogesh Deveshwar and another, consumer case number 1619 of 2018, after appreciating evidence on the aspect of distress, trauma and destroy of bodily career because of faulty haircut, the National Consumer Disputes Litigation Commission awarded compensation of rupees 2 crores. This matter is now pending. The special petition arising out of the said order passed by the National Consumer Dispute Litigation Commission is pending before the Hon'ble Supreme Court. Supreme Court will at some stage decide whether the award of rupees 2 crores of compensation by the National Consumer Disputes Litigation Commission is adequate or excessive. We are all awaiting for the judgment of Supreme Court in that matter. And so far as execution of the orders passed by the Consumer Protection Act is concerned, both the orders, whether it is under the Consumer Protection Act or it is under the Arbitration Act, all these orders are to be executed as if decree of the civil court. One important question which arises and which I must address before I conclude my lecture, that if there is an arbitration agreement between the parties where one of them is consumer and the goods purchased by him or services availed by him, they are not of the commercial nature, then if he invokes the provisions of Consumer Protection Act, whether application under Section 8 of the Arbitration and Conciliation Act can be entertained by the Consumer Protection, by the forum available under the provisions of Consumer Protection Act. In this regard, I would like to invite your kind attention to Section 8 of the Arbitration and Conciliation Act, which clearly provides that a judicial authority before which an action is brought in the matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Now, in view of the amendment to Section 8 with effect from 23rd October 2015, question arose whether in view of such amendment where it provides for a mandate that the court shall refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. And when the subject matter of the arbitration is the subject matter of suit before any judicial authority, whether parties can be referred to arbitration or not. Prior to this amendment, what was the view taken by various courts? After this amendment with effect from 23rd October 2015, what is the view taken by Supreme Court? I would like to inform you some of the citations about this. Supreme Court in case of Lucknow Development Authority versus M.K. Gupta, 1994, 1 Supreme Court cases 243, has held that the word consumer is a comprehensive expression. It extends from a person who buys any commodity to consume, either as eatable or otherwise, from a shop, business, house, corporation, store, fair price shop, to use of private or public services. The Consumer Protection Act 1986 opts for no less wider definition. It is in two parts. The first deals with goods and the other with services. Both parts first declare the meaning of goods and services by use of wide expressions. Their ambit is further enlarged by use of inclusive clause. For instance, it is not only purchaser of goods or hirers of services, but even those who use the goods or who are beneficiaries of services with approval of the person who purchased the goods or who hired services are included in it. As you all know, the Consumer Protection Act 1986 is repealed by the Consumer Protection Act 2019. Section 3 of the Consumer Protection Act is in perimetria with Section 100 of the Consumer Protection Act 2019. Section 100 of the Consumer Protection Act 2019 clearly provides that the provisions of the said Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. Supreme Court in case of Fair Air Engineers Private Limited and other versus N.K. Modi, 1996, 6 Supreme Court cases 385, has held that provisions of the Consumer Protection Act are in addition to and not in derogation of any other law, including Arbitration Act, and are intended to provide inexpensive and expeditious remedy. In another judgment, in case of Skypack Couriers Limited versus Tata Chemicals Limited 2000, 5 Supreme Court cases 294, the Honorable Supreme Court had the occasion to consider the provisions of Consumer Protection Act 1986 as well as Consumer Protection Act 2019 and also the provisions of the Arbitration and Conciliation Act 1996. Supreme Court, after considering the scheme of these acts, held that even if there exists an arbitration clause in an agreement and a complaint is made by the consumer in relation to a certain deficiency of service, then the existence of an arbitration clause will not be a bar to the entertainment of the complaint by the redressal agency constituted under the Consumer Protection Act, since the remedy provided under the Consumer Protection Act is in addition to the provisions of any other law for the time being in force. In case of Thirumurugan Cooperative Agricultural Credit Society versus M. Lalitha 2004 1 SCC 305, this court, the Honorable Supreme Court noticed the provisions of the Consumer Protection Act, and after considering the statement of objection reasons and the scheme of 1986, held that it is apparent that the main objective of the Act is to provide for better protection of the interest of the consumer, and for that purpose to provide for better redressal mechanism through which cheaper, easier, expeditious and effective redressal is made available to the consumers. To serve the purposes of the Act, various quasi-judicial forums are set up at the district, state and national level with wide range of powers vested in them. These quasi-judicial forums, observing the principles of natural justice, are empowered to give relief of a specific nature and to award, wherever appropriate, compensation to the consumers and to impose penalties for non-compliance with their orders. Supreme Court also held that as far as Section 3 of the Act is concerned, the provisions of the Act shall be in addition to and not in derogation of any other provisions of any other law for the time being in force. Having due regard to the scheme of the Act and purpose sought to be achieved to protect the interest of the consumer better, the provisions are to be interpreted broadly, positively and purposefully in the context of the present case to give meaning to additional extended jurisdiction, particularly when Section 3 seeks to provide remedy under the Act in addition to other remedies provided under other Acts, unless there is a clear bar. In another judgment in case of National Seeds Corporation Limited versus Madhusudan Reddy and another 2012 two Supreme Court cases 506, it is held by the Honorable Supreme Court that remedy of arbitration is not the only remedy available, rather it is optional. A person can seek reference to an arbitrator or file a complaint under the provisions of Consumer Protection Act. The law on this aspect is clear that even after considering the amendment to Section 8 of the Arbitration and Conciliation Act 1996, the Supreme Court has interpreted, and after comparing the provisions of the unamended provisions of Section 8 of Arbitration Act, the Consumer Protection Act 1986 and Consumer Protection Act 2019, it is clearly held that the provisions of Consumer Protection Act are available to the complainant, and it is in addition to the other proceedings and not in derogation of the other proceedings. I am happy to note that large number of people are going to appear for the post of member of State Consumer Dispute Redressal Commission as well as President and members of State Consumer Dispute Redressal Commission. Please accept my best wishes, and I hope the experience shared by me for the benefit of all of you will be useful for appearing for the test, if any, conducted for the post of member of State Consumer Dispute Redressal Commission as well as President and members of District Consumer Dispute Redressal Commission. I once again thank the Bar Council for giving this opportunity. Thank you very much.